Hello, everyone, and welcome to the Commonwealth Club. My name is Ladaris Cordell. I'm a retired Superior Court judge and author of Her Honor. Michael Waldman is the president of and CEO of the Brennan Center for Justice at New York University's School of Law, a nonpartisan law and policy institute that works to revitalize the nation's systems of democracy and justice. In his timely new book, The Supermajority, How the Supreme Court Divided America, Michael asks, what can we do when the Supreme Court challenges the country? He explores the tumultuous 2021 to 2022 Supreme Court term and the historic rulings that have altered the lives of so many Americans. So welcome, Michael Waldman.
It's so wonderful to be with you. We've had the chance here to talk before. I so admire all you do and the voice you give to justice in so many ways. And it's always great to be here at the Commonwealth Club. As a former presidential speechwriter, I remember that Franklin Roosevelt unveiled the New Deal at the Commonwealth Club in 1932 during the campaign. So we'll try to live up to that.
This is great. Well, we're going to unveil some good stuff tonight, too, so that's all right. Thank you. In 1 year, in one fell swoop, the supermajority has eliminated protections for reproductive rights, affirmative action, LGBTQ plus rights, and Biden's debt relief program that would assist thousands of low-income individuals. And I think that all of us are trying to wrap our heads around what just happened. How did we get here? What lies ahead for the court and the country? And what can we do to address the sense of helplessness so many of us feel right now? So we're going to discuss all of this and more with Michael Waldman. And believe me, he has all the answers. That's right. So let's start with how we got here. In your book, Michael, the historical perspective about the Supreme Court that you give us is so eye-opening and it's so important. For example, you write about the Reconstruction, where Congress enacted laws protecting the rights of the formerly enslaved. So can you tell us what the Supreme Court did in response there? And I don't know, my sense is it's eerily similar to what the supermajority has done with these recent decisions.
So you're right. The Supreme Court, most of the time, reflects whatever the elite political consensus is in the country, or the political consensus in the country is. In the period immediately after the Civil War, we had just had this incredibly convulsive war, the result of which was ending slavery and the enactment of the 14th Amendment, the 13th Amendment, and the 15th Amendment granting voting rights. And the purposes of those amendments was to create, they hoped, a multiracial democracy for the first time. And you actually had a flowering of that democracy in the South.
And that was Congress, right?
That was Congress, and it was the power to enforce these amendments in the amendments was given to Congress as well as courts because they didn't trust the Supreme Court, which had done the Dred Scott ruling. Well, when the justices of that time got their hands on those amendments, they gutted them. In cases like the Slaughterhouse case, they basically said that these didn't apply to states, they only applied to, they didn't apply to private actors, people like businesses, and we began to see the rollback, the backlash and the rollback of those rights at the end of the 19th century, which reminded us and reminds us that history doesn't only move in one direction. And that was a time when the country actually moved backwards when it came to democracy, equality, and freedom. So the great risk, of course, for us now is, are we in a moment of that nature now? And what role is this Supreme Court playing at this cusp of deciding what kind of country we're going to have?
So Reconstruction, there was a time when all of these rights were given to the formerly enslaved, right? We have the amendments. So is it that the Supreme Court then was just so racist that they just said, you know, we're going to undo all of this?
Some of it was that, and some of it was sort of equality fatigue on the part of the white Northerners.
Equality fatigue.
they were in a phase where they just wanted to make some money and do their thing. But they really reflected a reactionary moment in the country's politics. Interestingly, during Reconstruction, and you know this, black voter participation in the South was 90%.
It was huge.
There were black governors, black senators, black members of Congress, and it was taken away by terrorism, like the Ku Klux Klan, and by judicial terrorism. And something similar happened in the North. Not as bad, but the northern cities were being thronged with immigrants. Not from South America, from Ireland and Italy. And they passed laws there to make it harder for those people to vote. And again, courts upheld those and said, this democracy stuff, that's not for us. We're washing our hands of it. One of the lessons, unfortunately, is that for those of us who grew up in a time when we revered the Supreme Court, when we saw the Supreme Court as the ultimate place where rights were going to go to be advanced and protected, most of the advances for democracy and for rights have not come in the courts and have not come in the Supreme Court. They've come in the streets, at the ballot box, in legislatures, and that was a time like that.
Interesting. Wow. Well, so let's talk about, this is something I've been hearing lately, originalism and textualism. So one decision you write about in the book is the Dred Scott case, where the Supreme Court invalidated the Missouri Compromise of 1820. That was a law enacted by Congress, right? So you point out that in addition to that decision being blatantly racist, Dred Scott, and I'm quoting from your book, was also the first major originalist opinion. So talk to us about that. What is originalism, textualism, and Dred Scott? So
originalism, we don't have 4 or 5 hours for me to really get going. Originalism is the idea that the only legitimate way to read the Constitution is to ask what it meant to the people at the time it was ratified, and that we should be governed by history and tradition. And it may be easy to think, because we hear so much about it, that, well, this must be always the way the Supreme Court made its rulings. Really, it's about a year old. It was only a year ago that the Supreme Court fully and enthusiastically embraced this idea of originalism as the proper way to read the Constitution. There have only been 4 major originalist decisions in the country's history. 2 of them were last June. The Dobbs case, which overturned Roe v. Wade, and did so by quoting voices from the 1600s and 1700s, including an English judge who sentenced women to death for witchcraft. And the Bruen case, which was the day before, which was by far the most extreme Second Amendment ruling in the country's history, which said, in effect, you could not ask about current public safety needs when assessing a gun law, only history and tradition. Again, what they meant back in the 1700s. But there were only 2 other major rulings of that kind. The Heller case in 2008, which was the first time the Supreme Court said the Second Amendment granted an individual right to gun ownership, and Dred Scott. And basically, Dred Scott so discredited the whole idea. It was so notorious, they didn't try it again for another 150 years. If you think about it, the founding generation had just died off. The founding generation knew they were building a changing country. They knew that they'd written broad and vague language in the Constitution so the country could grow, evolve, and become something different than it had been at the beginning. Chief Justice Taney said, well, we're going to look at what the founders said, and what the decision said incorrectly was that Congress had no power under the Constitution to restrict and keep slavery out of the territories. In other words, it was national. Right. And also, as you know, it said that black people were so inferior they had no rights as citizens. This opinion not only was the first originalist opinion, it also marked a pattern that I think we may be seeing now, which is there was such a fierce backlash to it that it changed politics. It led to the election of Abraham Lincoln as president. It led to the rise of the Republican Party, and Lincoln's Cooper Union speech was his own version of originalism. He went back to the records of the Constitutional Convention and showed, no, really, they thought you could restrict or even eliminate slavery. So originalism, there are 2 big problems with originalism as we see it now being implemented. One is the idea that you can learn the answer by precisely understanding history. Anybody who knows anything about history knows we're arguing about it nonstop, and they argued among themselves all the time. James Madison, this is one of my favorites. We all quote and read this Federalist Papers. We've all done it as the oracular explanation of what the Constitution meant. In Federalist 10, Madison said, well, the thing we're trying to stop is faction. We don't want these political parties and special interest groups. It's all to stop faction. Then within 2 years, he organized a political party, the one we call the Democrats. He'd written the Federalist Papers anonymously. So then he wrote, under a different pseudonym, articles saying some people say factions are bad things. They obviously don't know anything about history. There have always been factions and parties. So the idea that we would try to understand the history, in the book I say the level of historical subtlety is like a medieval times costume restaurant. The other problem, though, is it's explicitly reactionary. It's explicitly backward looking. It literally says we in 2023 should be governed by the social views of property-owning white men from the 1700s, a time when, of course, women could not vote and mostly could not own property, when black people were enslaved, and on and on. That's an absurd way to run a modern country. No other country does it this way. Our country hasn't done it this way until last year.
Oh. So do you believe that the justices who embrace this originalism thing, do you think they actually believe this nonsense?
I think, by and large, they're flying a flag of convenience. I think that they are originalists because it is conservative. They are not conservative because they're originalists. And we even see, for example, in recent cases, Justice Ketanji Brown Jackson, in her first days on the court, has been quite energetic in putting forward an accurate historical narrative of the 14th Amendment.
Right.
That it was, in fact, explicitly aimed at lifting up the freedmen and the recently enfranchised, emancipated slaves. And there was ultimately no interest in that.
Wow. And it's so important, if you all listening and those here have not yet read the dissents written by Justice Ketanji Brown Jackson, you should read the dissents, and also by Sonia Sotomayor in the affirmative action case. They are amazing, they're beautifully written, but they give you the history, right? They educate, which is great. So there's something else I pulled. There's so many gems in your book. And so you write that after Congress passed the 13th, 14th, and 15th Amendments and the Civil Rights Act of 1875, and I'm quoting from you, the Supreme Court followed political opinion rather than leading it. So are you saying that the role of the Supreme Court is to lead political opinion? What do you mean exactly?
So in the course of thinking about this and researching the history and writing the book, I came to a few conclusions, some of which might be unexpected given that I lead the Brennan Center for Justice, which is a progressive-minded, nonpartisan law and policy institute. The Supreme Court is a singular institution. The part of the Constitution dealing with the courts is 1/10 the length of the part dealing with the president and the Congress, which the democratically accountable branches, which they assumed were going to be the main parts of the government. They mostly knew there would be judicial review, but this kind of judicial superiority would have been a surprise to them. Mm-hmm. Why does the Supreme Court have this kind of power? How does it have this kind of power? It has this power because we give it this power, because we, as a country, in some respect, trust the court to act like a court, to be in some respect beyond politics. We know they're political, but to not simply be a partisan or an ideological organ. Most of the time in the country's history, in fact, the Supreme Court reflects the consensus at the time. As I say, at least the elite consensus. It hugs the middle. There have only been a few times when the court was seen as extreme or unusually activist or ideological or partisan. And when that has happened, when there's been overreach, there's been a fierce backlash. It's been intense, it's been political, it's led to political campaigns, often political realignment, and the backlash has changed the country. I identify 3 times when that happened. The post-Dred Scott ruling, where the response was so intense that it helped bring on the Civil War. The second time was in the early 20th century, in the period lawyers know as the Lochner era, after a particularly notorious case. At that point, the justices of the Supreme Court, the Alitos of that day, thought that their job was to stop government from doing anything to protect workers, to protect public safety.
Was this the FDR time?
Well, it started out in the early days. It went on for decades. It was at a time of industrialization and social change and demographic change. And the court just stopped over and over again efforts by government at all levels to regulate the economy. And when I say these backlashes have been fierce and very political, one of the things I didn't realize until learning about this was that the fabled 1912 presidential campaign, I was not there, I'm not that old, but the 1912 campaign was this kind of epic campaign where Teddy Roosevelt ran against as the progressive bull moose candidate, ran against William Howard Taft, his handpicked successor, and Woodrow Wilson was the Democrat, and Eugene Debs, the socialist, was the 4th candidate. It's kind of a famous campaign. Teddy Roosevelt's big issue was the Supreme Court, was the reactionary rulings by the Supreme Court. He took them on. He had a bunch of ambitious ideas like there should be ballot initiative, voters should be able to overturn rulings if they didn't like them. But this was the issue. And this all led up for decades to the fight between Franklin Roosevelt, his cousin. You don't want to take on those Roosevelts if you're a Supreme Court justice, over the New Deal, where the Supreme Court then was striking down the New Deal laws, and they were about to go after Social Security and about to go after the labor laws when FDR, as you know,
said,
let's expand the court. A huge fight. Roosevelt actually lost and blew up his own political coalition, but the court backed down. And the third time was where there was that kind of backlash was after the Warren Court. And as you know, I run this is a complex point because I run the Brennan Center, which is named after the great liberal Supreme Court Justice William Brennan, who was a mainstay of the Warren Court. The Warren Court did so much that I care about, that we respect. It started with Brown versus Board of Education, but so many rulings where certainly the outcomes were outcomes I liked, but the change came so fast and so much, and on top of the social revolution happening in the country, that it created its own backlash.
So, but you're talking about, the Warren Court, the Miranda warning?
A lot of rulings on criminal procedure.
Right.
One person, one vote, equalizing legislative districts. New York Times v. Sullivan, which again is now under assault, but that is the ruling that basically empowered robust political speech in this country. But also banning school prayer and a lot of other flag burning, leading up to, and this was actually after Warren had passed away, Roe v. Wade, which struck down the abortion laws of nearly every state, and other rulings of that kind. And the backlash from conservatives building over time has dominated the politics of the next decades, and we have been living in it ever since.
So your chapter, you have one chapter called The Long Backlash, right? So you're saying that backlash culminate with the court making the decisions it's made in the past year?
We don't know if it culminated, but it led to them for sure. I mean, when you think of the rulings, Roe v. Wade was in 1973. The drive to overturn Roe v. Wade was a central plank for both Republicans, but for the conservative legal movement throughout that whole time. Finally, successful last year. Now, it was interesting. They were always one vote short for decades. That did suggest to me that perhaps they weren't entirely eager to get that extra vote because they might have known what the social response would have been. The idea that the Second Amendment reflects individual gun rights, that was pushed beginning in the 1970s also by the NRA. It was never what people understood the Second Amendment to mean. And again, it required a long, multi-decade campaign for constitutional change by these conservative organizations and movements. And so is this the culmination? I mean, it's an interesting...
They've gotten what they wanted, though, right?
Think about the last year. Roe v. Wade overturned,
Right.
affirmative action in higher education undone, this really radical gun ruling.
Second Amendment, yeah.
And, you know, when you look at the third, in the book, I'm, you know, focused on last year's rulings. I said that they crammed decades of social change into 3 days. First the Bruen case, then the Dobbs case, and the third case, which I think is one of the ones we're going to be living with in many ways for a long time, was a case called, it got a lot less attention, called West Virginia versus EPA.
Right.
And this was the beginning of a real assault on the ability of regulatory agencies to protect the environment, in that case on climate change, public safety, and in effect to act. And that has continued this term, and they will be doing even more damage, in my view, next term.
So just a little more on the backlash. So if the backlash really got started, let's say 1954, Brown versus Board, so have the majority of people in this country just, this backlash was just so quiet that it just all of a sudden, here we are? I mean, how did this happen?
So I think, so the backlash, it's an interesting thing about Brown, and I don't pretend to, you know, deep expertise on this. Brown, which was the first case, it was right after Earl Warren became Chief Justice. Right. And the case had actually been argued the previous term with a different Chief Justice, and the court was likely to issue a ruling overturning segregation in schools, but a divided ruling, and it would have been very messy. And the Chief Justice apparently was not very good at his job, and then he died. And Justice Felix Frankfurter said, this is the first concrete evidence I've ever had of there being a divinity that this happened. And so Earl Warren came in, of course. Right. He was the governor of California. And he said, this is just wrong and we have to do something about it. He made sure it was unanimous, and it was only 10 pages long, so it could be printed in those days in the newspaper. He knew this was a message to the country. The interesting thing is, it was not actually unpopular. In the whole country, in all the polls, it showed that it was actually very popular, and both the Truman administration and the Eisenhower administration argued for it, as well as Thurgood Marshall and the NAACP Legal Defense and Education Fund. When there was a backlash, yes, there were impeach Earl Warren billboards across the South, but really it was vented at the protesters, at Dr. King, at Lyndon Johnson, at the Democrats and Republicans in Congress who passed those laws. Unfortunately, it also shows us the limits of even that kind of ruling. A decade after Brown, only 3% of black children in the South were going to integrated schools. It was not until the democratically accountable branches passed the Civil Rights Act, passed the Voting Rights Act, prodded and led by the people on the streets, that the change really began to happen. So to me, the backlash actually came a little bit later.
So I believe that the Supreme Court is political. It shouldn't be, but especially I think it is now. And I think that the justices have historically, and I think you've made this point now, tried to cultivate the perception that the court is above petty politics. They're focused only on legal scholarship. And maybe the court did behave in that manner once upon a time. But in my view, with this supermajority that you write about, I think, in my view, they have completed the transformation of the Supreme Court into one of the most powerful political institutions that this country has ever seen. So am I overreacting?
I don't think you're overreacting. This is not checks and balances. This is judicial superiority. And judicial superiority wielded in a deeply political and deeply unwise way. There's been a power grab. This institution, with 9 unelected public officials serving for a lifetime, you know, they're not wizards, even though they wear robes. They're not religious figures. They're government officials acting in a way that is so abrupt and so, again, as I say, ideological, and in such lockstep, and with very gaudy disregard of public opinion on most of the things that they've ruled on. And the challenge we face from this is the country is moving in many respects in one direction. It's more diverse, it's younger, it's more open to government action on many things, and the court is veering sharply in the other direction. And that sets up the ingredients for a real crisis of credibility. There's also a political dimension to this. This is an empirical statement, not a partisan statement. One political party, the Democrats, have won the popular vote in 7 of the last 8 presidential elections. That's the longest winning streak in American history for a political party. The other political party has appointed 6 of the 9 Supreme Court justices. And that's not just because of Mitch McConnell. I mean, that goes back. The Democrats and Republicans have split control of the White House roughly evenly for the past half century. The last time a Democratic president's appointees were a majority on the Supreme Court was 1970. And here's a real trivia question. When was the last time a Democratic president appointed a Chief Justice of the United States? 1946. Whoa. So this is a very fundamentally small c conservative institution, but it has been captured now, I would say, by a faction, a very, very well-oiled, well-organized, and it turns out well-funded political operation. We know of the Federalist Society, that's the most visible part of it, enforcing an ideological lockstep, not only at the Supreme Court, but very often in the lower courts as well.
Wow. So will we, or are we already seeing a backlash to what the supermajority has wrought?
I think we are. I think we have seen that. I think there's plenty of reason to think it will continue, and whether it continues and how it continues will be one of the central political stories of the coming election and the coming years. As I said, again, when a court acts like this, there's often or usually a backlash. The long backlash took a while to build. We talked about Roe v. Wade was not actually that controversial when it was promulgated, and the evangelical churches did not object to it. They saw that as a Catholic issue. It took years for the evangelical churches and the religious right to get going on it. The reaction to Dobbs and these other rulings took minutes. We know that ballot initiatives passed all over the country, even in places like Kansas, even in Kentucky, where Mitch McConnell has spent years packing the courts with anti-abortion judges, passed pro-choice ballot initiatives. The midterm election, as you know, it's kind of a law of political physics that whichever party controls the White House does badly in a midterm. It's just the way these things go. And when the midterm was happening, you may remember President Biden talked about Dobbs and about democracy, about the threats to democracy. A lot of people said, you should not talk about that stuff. You should talk about inflation or crime or whatever other issues there were. The Democrats had the strongest midterm election performance of a party in control of the White House in decades as part of this backlash. And then the thing to me that is most interesting and most telling is the Wisconsin State Supreme Court election that took place in April. So Wisconsin, like most states, elects the justices of the state Supreme Courts. Whether that's a good thing or a bad thing, it's a different issue, but they do. And Wisconsin is a very closely politically divided state, the voters, between Democrats and Republicans. The legislature is massively Republican because of gerrymandering, but the voters are evenly divided. And that shows up usually in the votes for these Supreme Court races. It went from an evenly divided electorate to the liberal candidate winning by 11 points. Political scientists will tell you that doesn't happen. That is an earthquake. And if replicated around the country, that becomes the ingredients of a political realignment. So I think that there's a backlash. I think it's being felt. Part of the question will be, how do the Democrats and how do the Republicans respond to this moment?
So let's talk about some fixes, okay? Because many of us want to believe that we can restore sanity and respect for the Supreme Court and for judicial precedent. So I'm putting a lot on you, Michael, because I'm turning to you for some hope now, okay?
I always have to remember to do the hope part.
We need the hope, all right? So let's start with the confirmation process for Supreme Court justices. So in my view, it's a circus, and I'm being kind. So what's your take on the confirmation process? And
So you're certainly right about that. One scholar writing about the confirmation process called it a stylized, ritualized farce. That was Elena Kagan when she was a young law professor, and it's gotten worse since then. Back then, the nominees were really good at dodging the questions. Now, they don't dodge the questions. It's more the senators performing for their tweets and for being put out on cable news. A lot of the problems with the Supreme Court really are problems in Congress. They're really problems in the country. It's the polarization and the politicization heading into the nomination process. What can be done about it? It's, of course, hard to kind of put the genie back in the bottle. It's an interesting thing that many folks don't remember. When we think about Joe Biden, who was the chair of the Senate Judiciary Committee for many years, and we think of confirmation hearings, of course, we think of the Clarence Thomas hearing and how badly they handled Anita Hill and her charges against then Judge Thomas. But a few years before that, Biden had led the committee in the Bork confirmation, which was actually 2 weeks of fairly high-level public debate over judicial philosophy that led to many Republicans and the Democrats voting to defeat Bork. One of the things that I think could be done is, as part of reforms, presidents should be, I think that the most sensible reform that could make a big difference in a number of different ways is to have 18-year term limits for justices and to give every president the ability to nominate and appoint a justice every 2 years, to regularize it. That would drain, I think, some of the toxicity out of the process, drain some of the circus-like atmosphere out of the process. Maybe not, but I think it's the best chance we have. Again, the more we recognize, people say, well, wouldn't that make it all really political? Wouldn't candidates running for president sort of say who they're going to appoint to the court? Well, Donald Trump actually did that. It's not the end of the world if they're more overt about their appointment plans.
But how do we get the term limits? How does that happen?
So the idea behind term limits is a basic premise, which is that nobody should have too much public power for too long. It's a core value, and it's actually something that George Washington reflected when he limited his own term to 2 terms. The interesting thing is term limits are actually very popular, and they're popular across the political spectrum among Republicans and Democrats, progressives and conservatives. I found this out in an interesting way. I was appointed by President Biden to be a member of the Presidential Commission on the Supreme Court that met in 2021. And these commissions, government commissions, they're often ways to make sure nothing happens. And we were actually instructed at the outset not to reach conclusions. And we didn't. It was a government agency that worked as intended. But we heard from dozens and dozens of public witnesses, from left and right. And some were for court expansion and others were against it, and some were for an ethics code and others were against it. Over and over again, they said, oh, but I'm for term limits, of course. There's a national consensus for this that is not recognized. John Roberts is a supporter of term limits, for example.
Really?
How can you do it? You certainly can do it by constitutional amendment. At the Brennan Center, we believe also you can do it by statute. We actually, a couple of weeks ago, put out a proposal. Basically, judges can take what's called senior status. They remain as judges, they remain as federal judges, but their role changes. They don't have all the power and responsibility of regular judges. What our proposal would do is say that after 18 years, a justice becomes a senior justice. And we believe it's constitutional. There's plenty of basis for thinking it's constitutional. There's, of course, a complication, which is who would decide that it was constitutional?
Right.
The Supreme Court. But honestly, I do think that if, in the chance that the public voted a Congress into office that passed this, and then they passed it, and then the Supreme Court struck it down as unconstitutional, I think you'd get a constitutional amendment pretty fast.
Interesting. What about expanding the number of justices on the court?
So as you know, there's a great deal of energy for that idea among progressives, especially. In this instance, it's rooted in the very real fact that at least one and maybe two of these seats were effectively stolen. Mm-hmm. As you recall, when Justice Scalia died a year before the new presidency began and Barack Obama appointed Merrick Garland, the response by Mitch McConnell and the Senate Republicans was they wouldn't even meet with him and simply would not consider the nomination. But then when Justice Ginsburg died, as the early voting was already underway, they rushed Amy Coney Barrett's nomination through just days before Election Day. Basically, Trump had already lost the election when you count the early votes by the time she was confirmed. There's a great deal of support among Democrats for this idea. It is certainly constitutional. The size of the Supreme Court is set by Congress, and it's actually expanded and contracted over the years. I think it's important that we are aware of the pitfalls of this idea. There are substantive pitfalls. It would lead, I think, pretty quickly to a retaliatory spiral. Democrats would add 5 and Republicans would add 5, and pretty soon it wouldn't be able to fit the number of justices in the courtroom. There are risks, to judicial independence. But even more than that, I think that there is a risk of triggering a latent support for the Supreme Court that a lot of people have, people who right now think the Supreme Court is acting illegitimately. FDR found that out the hard way. He had just won the biggest electoral landslide in American history. He had 70% of the Senate controlled by his party. And the Supreme Court was striking down the New Deal in the middle of the Great Depression. But when he tried to expand the court, it blew up his political coalition and, was not a success. And we even see in the last day or two and the weeks before that on the streets of Tel Aviv, the reaction people have when they think there's something that threatens the courts. So I think those of us who are working for term limits or any of these reforms need to be really careful and aware of the true potential for public opinion on these things.
Well, I have received several wonderful questions from our audience here, and I will do my best to incorporate those along with the questions I still have for you. So one question is this, and it really gets back to the confirmation hearings. Can Supreme Court justices be impeached for lying at their confirmation hearings?
I mean, certainly. I can't think of who anybody might have in mind. So the Supreme Court justices can be impeached just the same as other officials. It has not happened. The last time it was seriously attempted, I think, was in the early 1800s. The question is highly relevant, among other things, because of the confirmation hearings of Justices Kavanaugh, Gorsuch, and Barrett, and the answers they gave on what their attitude was toward Roe v. Wade. And I think, if you actually look carefully at what they said, these are pretty lawyerly lawyers. They said things like, oh yes, it is a precedent. It is a serious precedent. I really respect precedent. But they did not say, I will not, by and large, they did not say, I will not overturn Roe v. Wade. They danced away from that. There is, however, one justice who almost certainly lied under oath about this, among other topics, in their confirmation hearing. Clarence Thomas testified under oath that he had never discussed Roe v. Wade with anyone ever and had never expressed an opinion on the subject, even though he was in law school at the time the opinion came down. And people at the time said, Friends of his said, oh, that's not true. We talked about it all the time. He also testified that he believed strongly in a right to privacy in the Constitution through the 14th Amendment. He forgot that one as well. So that was the most explicit fib that I could find in these confirmation processes. So, there's, I think as a political matter, it's pretty hard to go after a justice for something they did in the confirmation process when they've been in effect ratified by a vote of the Senate.
Yeah. I mean, there is no statute of limitations on impeachment, right? I mean, it doesn't matter. But
no.
In my view, there's just not the political will to take this up.
There's not the political will, and we certainly see that with we've now learned the intrinsic weakness of impeachment when it comes to presidents. For a long time, that was seen as the really significant and serious barrier to presidential misconduct. I mean, when Watergate happened, it was such an incredible stigma that Nixon would get impeached that he resigned before they could vote because he didn't want to be impeached. Now we've had 3 failed impeachments in the last quarter century. And with each failed impeachment, unfortunately, the sanction diminishes in terror. Right. And I don't think it is very likely that there's going to be impeachment. But I would say this: we haven't talked about the ongoing controversies around Justice Thomas and Justice Alito.
That was coming up next. Code of ethics.
They're billionaire buddies, and
right.
they're we talk about these ethics issues. To me, what we've learned in many respects is not about ethics, but about corruption. Congress certainly has the power to investigate. In fact, Abe Fortas, who was a justice, there were impeachment investigations. There were investigations when he took money from a wealthy benefactor. And again, the stigma was such that he resigned in 1968. So Congress has tremendous power. Only now, very gingerly, very timidly, but markedly is it beginning to use it.
Can Congress create a code of ethics? I mean, the court is not in a hurry to do it. So,
maybe we never opened the envelope when they sent us the code of ethics. No, the Supreme Court, as we now all know, is the only court in the United States without a binding code of ethics. All the lower federal court judges have to, and certainly state court judges do too. And my sense is that a lot of the other federal judges are pretty miffed about the whole thing. Nobody is so wise that they should be the judge in their own case. That's a basic adage. That's clearly the case here as well. Not just things like taking gifts and disclosure, but basic matters such as recusal from cases where you have an interest or where there's some kind of conflict of interest. Even before the recent revelations, in my book, I talk about what we learned last year about Justice Thomas's wife, Ginny Thomas, and her involvement in the movement to overturn the results of the 2020 election leading up to the insurrection. She was at January 6th. She said she went home because it was cold. But she was deeply involved. And there was a case when there was the tremendous investigation by the January 6th committee. And it was a case about whether the National Archives could turn over the records, and former President Trump tried to stop it. The vote was 8-1. Justice Thomas was the one dissenter. Mm-hmm. It turned out that the documents included messages from his wife urging the overthrow of the free and fair election. He never recused himself, meaning he voted on it. He never disclosed it. And again, other courts would not be able to get away with that. So there's a deep rot here. So Congress can pass this. The Senate Judiciary Committee next week on the 20th is writing ethics legislation for the first time, but they don't have to wait for Congress. The Supreme Court could do it too. John Roberts professes to be an institutionalist. I think he is an institutionalist in the sense that he is well aware of the public standing of the court. He could push this through. He's just not doing it.
I'll ask you to speculate, do you have a notion why he's not standing up?
It's hard to know what goes on behind, behind the velvet curtain. Apparently, you need a unanimous agreement. And one can imagine perhaps he doesn't have a unanimous vote on this.
Wow. Interesting question from someone in our audience. If Clarence Thomas were forced to resign, can his votes as a Supreme Court justice be vacated or changed?
No, I don't think so. In other words, the past votes. I mean, again, as I say, there have been other justices who've resigned in controversy, and their votes were on the books.
Got it. You mentioned Justice Roberts, and here's another question. What do you think of Chief Justice Roberts' letter to Congress rejecting its invitation to come speak to them?
I think that on the one hand, he is aware of the court's credibility challenges. We've seen in past cases over the years him seeming to cast very strategic votes to avoid backlash, to avoid the controversy. The most noteworthy of one was when he switched his vote, apparently, from overturning the entirety of the Affordable Care Act of Obamacare to finding a way to uphold it, because he knew that would have just been absolutely devastating to the court's standing had they done that. On the one hand. On the other hand, these folks are pretty arrogant. They don't want people asking them questions. They jealously guard their institutional prerogatives, but they go well beyond what the Constitution requires, or what, again, it's supposed to be co-equal branches, not silent sovereigns up on Mount Olympus.
Maybe we should change the name of the court. I mean, Supreme. Maybe it just goes to there. Okay, another question. Does any other advanced democracy rely so much on its highest court, or is the United States exceptional? Is it not better to seek rights protection politically instead of judicially?
That's a great question, and it is in a lot of ways the fundamental question that I try to wrestle with throughout the book. There's no other democracy that has as powerful a high court as we do. Part of the reason is we have a written constitution. We revolve our politics around the Constitution more than most. Other countries do not have an unelected court, a court with lifetime, certainly none with lifetime appointments, and none that feels as freely able to overturn acts of Congress or of the laws of other states. We've learned a lot, actually, about Israel in recent months, because the Supreme Court there has a lot of power as well. But the Parliament has even more power. And here, because of the often polarized and paralyzed political process, that creates a vacuum into which the Supreme Court has stepped. So I certainly don't think that there's anything among major democracies that rivals what we have. And again, there have been times when that's been a positive thing, or where the court has not done a great deal of harm. The only time where the court was ahead of the country in advancing rights and promoting equality was, as I say, in the 60s and 70s, the Warren Court era. But most of the time, the court plays an important role and can still play an important role. We want a powerful judiciary to uphold rights and protect fairness. But when you have this branch acting as this branch is now acting, and again, enforced by a very robust and secretly funded and very, very disciplined outside political force, we've never had anything like that before in our history.
I want you to talk to us, if you can, a bit about the power of dissenting opinions. So I looked at dissents that have been written by members of the supermajority. So let me just run a few by there. And then if you could talk to us about the power and what this all means. All six, this is the members of the supermajority, have questioned in dissents now the validity of the Miranda warning. Okay? Two of them, Thomas and Gorsuch, have asserted that a defendant does not have the right to a state-appointed lawyer, but rather the right to the assistance of a paid or volunteer attorney. 4 of the 6 have questioned the right to be free from warrantless police searches. Again, they're questioning the constitutionality. Thomas, Roberts, and Alito have questioned the validity of the 8th Amendment's ban on cruel and unusual punishment in sentencings of adults and juveniles. And Thomas and Alito have questioned the constitutionality of same-sex marriage. And that's just a bit. There's a lot more. So are they sending messages to lawyers, to groups, to get on it and start attacking these? So talk to us about dissents.
So first thing I want to say is that is an extraordinary presentation, and I hope you get the chance to write it, because I've not seen it laid out in that way. What's noteworthy here, and I don't hear any dissents to that. What's noteworthy is these are folks in the majority. What they're doing is they're leaving breadcrumbs. They're sending out signals to lower court judges. Hey, try it this way. Try it that way. Sometimes you'll see concurring opinions as well, where they'll lay out a roadmap. Chief Justice Roberts, we think of, he's the Chief Justice, but the Chief Justice doesn't really have that much more power than the other justices. He holds the gavel, but much of the time in recent years, and certainly last year, Roberts held the gavel, but Thomas held the power. He was the dominant force. And for years before that, Thomas would do these dissents. He would often dissent by himself and put forward ideas that were seen, and were, in my view, as really fringe, really radical. But over time, they were signals and language and idea generators for other parts of the judicial system, leading eventually to majority opinions. And so it's an important, interesting understanding of the role of these kinds of dissents or concurring opinions when these folks have the swagger and self-confidence of knowing they're in the majority. There's another role for dissents, which we saw, as you mentioned, in the dissents by Justice Sotomayor and Justice Jackson in the affirmative action case, in many dissents by Justice Kagan on cases involving democracy, voting rights, campaign finance. There's a nobility in dissent. The dissents are not written for other judges. They're actually written for all of us. This is a time-honored and important role throughout history. During that period at the beginning of the 20th century that I mentioned, the Lochner era, there were 2 justices. First of all, Justice Harlan was the great dissenter in Plessy versus Ferguson, and also in Lochner. But the 2 justices who were known over and over again for their dissents were Justice Holmes and Justice Brandeis. And it was Holmes and Brandeis' dissent was this like rallying cry for progressives. It would now be a hashtag, or something like that. They obviously didn't have that then. And I think it's really important that these justices not lose heart and understand that waving the flag, holding the flag high, speaking to the country is a pretty important function. And it can change minds and eventually become the majority opinion.
Wow. So I want to talk, if we could, just for a couple of minutes about the affirmative action decision, the one overturning affirmative action. So again, my view is that this decision is really going to impact Black and brown applicants at elite educational institutions, not others. So what's your take on that?
These justices live in such a bubble in a way, as so many do, and that they almost all but one went to Harvard or Yale Law School. There's only about 100 academic institutions in the United States that don't accept most applicants. But we have a system that purports to be a meritocracy, but is its own form of an aristocracy. And I think they think that these institutions can make a case that, we're just being meritocratic, we're just relying on the facts. But that it really leaves out the vast number of people and the vast numbers of pathway to opportunity that need to be opened. And unfortunately, I don't think they mind, and I think in some cases they probably are not at all unenthusiastic about the idea of those doors being closed in those institutions. They may overestimate the importance of those institutions, but it's an ugly opinion if you read the majority opinion. This is where one of the key things was in the dissent. In the oral argument, and this was Justice Jackson's first week or two on the bench, she was right near the beginning of her tenure. She asked a question which was hard to respond to, hard to answer. She said, in the case, it was two cases. It was Harvard private school and University of North Carolina public school. And she said, there's two applicants to the University of North Carolina. One writes in their essay, I want to go to UNC because my grandfather went here. And it would mean a lot to me to go here because of that reason. And the other applicant writes, I want to go to UNC because my grandfather could not go here because he was black. And so it would mean a lot to me to go here for that reason. She said, are you saying you can't take that second essay into account, but you can take the first essay into account? That you can only have affirmative action for legacies and white people, but not for people of color. And so when you read in the majority opinion, I think it is far too optimistic to think of it as a loophole. But Roberts says, now, of course, you can have essays. He was responding directly to her. And of course, there will be ways, one hopes, that schools will continue to find ways to have diverse student bodies, to have student bodies that open doors to all different kinds of people, that look at economic adversity and other things as well. There is emphatically there should be and will be a movement to challenge legacy admissions and athletic admissions, especially for sports like water polo or crew that only exist to get kids into school. Yeah. Sorry for the water polo fans out there.
So when Justice Roberts wrote that exception, and I mean, what he was doing really was putting the burden on the applicant to have to even raise the issue of race, and it has to be done gingerly, right?
And it puts a burden on the applicant also to center those issues in their essays, even if they wouldn't otherwise want to.
That's right. Do you recall how the lawyers for the plaintiffs in that case responded when Justice Brown Jackson asked that question?
I think they stammered, as I recall. I think they said, "Well, no, that would be okay." But it was such a brilliantly constructed question that they ought to teach it that one in law school.
We have a question from our audience. You discussed originalism, and you used the example of Dred Scott. Justice Brown Jackson has stated that she is an originalist. Can you discuss the differences between her view and the other originalist judges on the Supreme Court?
So during her confirmation hearings, she testified, and it was, to me, painful to watch in a sense. She said, I believe the meaning of the Constitution is fixed, and I pledge only to enforce those rights that are deeply rooted in history and tradition. And I thought, this is just terrible that they're making her say all this stuff, to get confirmed. She has been quite, I'm being at least a little facetious there, but she has been enthusiastic about making arguments based on originalism, on a true understanding, a true reading of the history behind and the intention behind things like the 14th Amendment. This came out in the arguments on the affirmative action cases. It also came out even earlier in her tenure in the first major argument where she sat, which was on the Voting Rights Act, where again she made the point that the 15th Amendment was explicitly focused on remedies that were not race neutral, that were designed to overcome the legacy of slavery. I worry that her gift for making these originalist arguments will mislead us into thinking that making originalist arguments ultimately is the right approach to how to understand the Constitution. First of all, they're going to mostly be in really eloquent dissents. I think it also validates the premise that the only way we in 2023 should build our country is by some past moment and what people back then thought. And that is not how the Supreme Court has ever ruled up until now. It's not how a modern, growing, changing country can organize itself. In England, when they have a law that's being proposed, they don't sit around and say, well, that's really interesting, that's a good idea. What did King George III think about that? I think it is true, without a doubt, that the 14th Amendment in particular was a powerful document aiming to promote equality in a fairly radical way for the recently freed slaves. It was not meant to cover women, and certainly was not meant to cover LGBTQ people. And so we still ultimately have to try to tease out of it the principles behind it, not just the history behind it. So I again, there's a lot of back and forth. When you have to make the originalist arguments, you have to do it. On the gun issues, for example, the Bruen case, which was this Second Amendment ruling last June, it was about the law in New York State and other states prohibiting the carrying of weapons. There's a vast amount of historical evidence. We've had restrictions and even bans on carrying weapons from the beginning of the country. The history was actually on the side of New York State. Now that the Supreme Court has said only history and tradition, meaning literally the way they rule on it, colonial era laws, people have no choice but to look for analogies from earlier periods. Now, to give two examples of how nutty this has become, New York State passed, after its law, which had been passed in 1911, so to me that's history and tradition too, I guess. They passed a new law quickly. An upstate judge, a federal judge, said, well, history and tradition, for that, if there are two examples from colonial era laws, that's a mere trend. For it to be tradition, you need three. And I can find no tradition of laws banning guns at sleepaway summer camps. Therefore, it's unconstitutional, because they didn't have them. Let alone subways, which would not be invented for another 100 years. It's like a parody. There's something that's pretty disturbing that came out of Texas. The Fifth Circuit Court of Appeals is a very conservative federal court of appeals. There, the law being assessed, and there are dozens of long-standing gun laws being challenged and being knocked down all over the country under this absurd standard. There, the law said that you could take away a gun from somebody with an adjudicated record of domestic violence. And the Federal Court of Appeals said, well, history and tradition, back then, they think that was so bad. So that's unconstitutional. Right. This was such a bad case. The Supreme Court took the case. I actually think they may use it to pull back a bit because of the carnage that's unfolding because of their earlier ruling. I say this very sadly, but our time is just about up. And this has just been wonderful, Michael. I have one final question, and you only have a minute to answer it, my friend. So it is this: if you were locked in a room with a supermajority, all of whom are seated and must listen to you, what would you say to them? First of all, I would say, could you introduce me to some of your really rich friends that I've been reading about? They look like they're having a pretty good time. I would say, without a great deal of faith that it would be heard, listen to the people outside these walls. I don't think I could change their minds, but I think I could change their political calculus. I think that they profess loudly to not care about the public and public opinion, or even the impact of their rulings. I don't believe it. I think they're duff protesting too much. The louder they say it, the less I believe it. And I think they live in a bit of a bubble, and that they are sowing the whirlwind in a way that they have to feel the walls rattling a little bit. The thing that gives me hope is that we're talking about this, we're yelling about it, we're voting about it, we're doing all these reforms, passing laws, all the things that we the people can do. That's what gives me hope, and that's what I would encourage them to think about.
I would tell them to read your book.
Thank you.
Our thanks to Michael Waldman, President and CEO of the Brennan Center for Justice at New York University School of Law, for joining us today. We encourage you to purchase a copy of Supermajority here or at your local bookstore. And if you would like to support the club's efforts in making virtual and in-person programming possible, please visit their website, www.commonwealthclub.org. I am Ladaris Cordell. Thank you so much. Onward.